So if you were looking for a few more cases or had a few different questions about different civil liberties cases, this was the assignment I also gave you in class. This was civil liberties, individual rights. And if you go to Canvas, it is under supplemental activities, civil rights cases 2019. If you're curious and want to know a little bit more about like different First Amendment rights, you could take a look through. I added a few different cases. You can use the website oyez.org, oyez.org. There's Lemon v. Kurtzman, Burwell v. Hobby Lobby to look at free exercise of religion, Brandenburg v. Ohio, that case I mentioned before, Cohen v. California, Tinker v. Des Moines, Texas v. Johnson, or a few more speech cases. Looking at the press, Near v. Minnesota, Hustler Magazine Incorporated v. Falwell, that looks at like satire and its protection under the First Amendment. Freedom of Assembly, so Village of Skokie v. National Socialist Party, Boy Scouts of America v. Dale, and then on the back, a couple other cases relating to other individual rights, like the right to privacy, the right to own a firearm. So additional cases like Griswold v. Connecticut, Lawrence v. Texas, District of Columbia v. Heller. The ones that are highlighted are the required cases. If you're curious and want to know a little bit more about some of these issues, just go through and do this assignment. It's just supplemental. It's there to help you and kind of more of like an enrichment opportunity. I'm really disappointed that we're not in school for a variety of reasons, but I really like civil liberties, civil rights. This is the area that I took like most of my political science classes on. I took a lot of civil liberties classes and a lot of administration of justice classes. So like the classes that like you take if you want to be a cop. So I've taken a lot of like I have a lot of coursework on these issues. And that's why I'm so disappointed that rights of the accused and the new exam, there really kind of isn't anything. There's one case, and that case is Gideon v. Wainwright from 1963. So the constitutional question, is the Sixth Amendment right to an attorney a fundamental right protected by the 14th Amendment? So a man, Clarence Gideon in Florida, he was arrested and accused of breaking into a pool hall and stealing money, and he couldn't afford an attorney. He had to defend himself. He didn't know the rules of the court. He didn't know how to introduce evidence, and he essentially was found guilty. And when he was in prison, he wrote a letter asking for an appeal. He read a lot of books about the law, the Constitution, and he argued that he was denied due process of law because he could not afford an attorney. And due process of law is having a fair trial with a judge and a jury and all the other rules of making sure that you are not just sent to prison without reason, that you get a fair trial. That's called due process. And the court agreed with Clarence Gideon that the right to an attorney is a fundamental right. And they were arguing that to deny someone legal counsel, so an attorney, is to take away their due process. And that's a fundamental right that's protected by the Sixth Amendment and the 14th Amendment. And that the government must provide attorneys to those who can't provide their own. So what happened is that Clarence Gideon, he received a new trial with an attorney, and at his new trial, he was found not guilty. There is a film called Gideon's Trumpet that if you go to Canvas and take a look at the YouTube playlist I put together, so Civil Liberties playlist, I did link to or put on that playlist the film Gideon's Trumpet. So that's it in terms of cases that you need to know relating to rights of the accused. That makes me crazy, like I said, because this is something that I personally am interested in. But if you go to Canvas and take a look again at supplemental activities and click rights of the accused, you can go through and take a look at a few more other important cases. So the rights of the accused, those are things in the 4th, 5th, 6th, and 8th Amendments. So use your pocket constitution or the interactive constitution online, read those 4 amendments, figure out what's in them. And then there are a bunch of different cases. Mapp v. Ohio, Gideon v. Wainwright, which is required, Miranda v. Arizona, Schimel v. California, Gregg v. Georgia, Roper v. Simmons, Atkins v. Virginia, Arizona v. Gant, Riley v. California, Carpenter v. United States, Flowers v. Mississippi. And some of these cases are pretty recent. They deal with things related to whether or not your car can be searched with or without a warrant. Cell phones, access to cell phone data, issues related to capital punishment, so like lethal injection, whether or not being executed for a crime is constitutional. Does that violate the Eighth Amendment? And there are a number of cases that deal with these issues. And essentially it's asking, how does your protection of rights of the accused compare to protection of other rights? So like compare like the rights of the accused to freedom of speech, freedom of religion, and just kind of compare them to the previous assignments. So there are a few other important cases that I think you need to know the concepts of, like you need to know things like the exclusionary rule, even though the cases themselves aren't mentioned by name on the AP exam. So the case Mapp v. Ohio in 1961, that establishes the exclusionary rule, which is essentially that evidence obtained improperly, so like a confession or items that were taken without a warrant, they can't be used at trial. So if something was taken improperly, you can notify your attorney, and your attorney will bring that before a judge, and the judge will rule that you can't use that at court. And then another case, Miranda v. Arizona. So the police have to inform arrested suspects of their rights under the Fifth and Sixth Amendments. So like confessions and evidence given without what's called the Miranda warning cannot be used at trial. And that's, I'm sure you've seen this on television, or maybe you've experienced it yourself. I don't know. Maybe you've been arrested. But you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer. So this is referencing the rights that you have in the Fifth Amendment and the Sixth Amendment. And that the argument was not everybody knows their rights. Not everybody has finished school. Not everyone paid attention in school. Not everyone learned these things in school. And to assume that Americans just know their rights is an incorrect assumption. So the police need to tell you that you don't have to speak and you can ask for an attorney. So that's called your Miranda warning. All right, so when do they not need a warrant? I'm just going to put these up here, that this is not on the AP exam. This is just something that I'm sharing with you. So if you consent, if you say, yes, go ahead and search my house, then you don't need a warrant. Incident to lawful arrest. So if you are arrested otherwise lawfully, they can search your body for items. They can search the area immediately around you without a warrant. If it's in plain view, so if it's something that's just kind of like laying out there in the open, like if it's like you've like a big bag of drugs and the backseat of your car, like anybody can see that. So if you don't need a warrant to obtain that evidence. Hot pursuit, like if you rob the Safeway and the police are chasing you and they follow you into your house, they can do that. Stop and frisk, you could ask Mike Bloomberg about that, but you need reasonable suspicion. So if you're like stumbling down the street, that would be reasonable suspicion to assume that maybe you're high and they can just search your body without a warrant. Vehicles, they would need probable cause to believe that the crime was used or the car was used in a crime, or believe it to contain evidence of a crime, but only if that crime is related to the reason for pulling over the vehicle. So like if you got pulled over for a DUI, they can search the vehicle for drugs. And that is, again, connected to like in plain view, incident to lawful arrest. So if anything is just out in the open, like sitting in your back seat, of course, the police don't need a warrant because it's right there. They can see it. And the same thing for like you're being arrested otherwise, like you're pulled over because there's an outstanding warrant, and they can search immediately like in your vehicle for like weapons to make sure like you're not gonna like harm the officer. There you go. Those are the warrant exceptions. There really isn't a lot on the AP exam relating to rights of the accused. I don't know why. I think there should be. I could go on about this for a very long time, but unfortunately, we don't have that time. So let's talk about other individual rights. The case Roe v. Wade from 1973. This one is asking, does the 14th Amendment protect a fundamental right to privacy? And the answer was yes. The right to privacy protects a woman's right to have a decision to have an abortion. But this right isn't absolute. The government can make decisions that protect a woman and her unborn child's health. That comes from a later case called Planned Parenthood v. Casey. And it specified that the government cannot place an undue burden on that woman's right. So they can't make it so you have to jump through like a million hoops to get your abortion. And in this case, Roe v. Wade, that it was dealing with a case or a law in Texas that prohibited women from seeking an abortion. And what happened as a result of this is that the right to privacy was again acknowledged as being something that is a fundamental right in the Constitution. It's protected by the 14th Amendment. Therefore, the states have to comply. The states have to give you your right to privacy. And this right to privacy isn't mentioned anywhere in the Constitution. It's an implied right. And it has been used to justify a whole bunch of things. The use of birth control, consensual adult sexual intercourse, same-sex marriage have all been justified as being constitutional and a constitutionally protected right through the right to privacy and the 14th Amendment. So McDonald v. Chicago is another case you need, and this is asking, does the 14th Amendment protect a fundamental right to own a firearm? And the decision was yes. The Second Amendment protects an individual's right to own a firearm, and it is therefore incorporated and applied to the states through the 14th Amendment. That privacy and your right to own a firearm are things that are fundamental rights, just like your freedom of speech, just like the freedom of the press, just like your right to have an attorney, just like your right to have a jury trial. That your right to own a firearm and your right to privacy are on the same level and receive the same protection. So these rights are controversial, and they're controversial because they're really not that clear. Specifically privacy, it's not mentioned anywhere in the Constitution. And those that argue against this right, they say that it's up to the states. So if Congress wants to pass a law about abortion, they can. But if states want to make their own decisions about abortion, they can go ahead and make those decisions. Because the 10th Amendment says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. So that's where they're making that argument. And then advocates, those in favor, they point to the 9th Amendment. They say that, like, hey, there are other rights, even though they're not listed in the Constitution, they are acknowledged by the 9th Amendment and they do exist. And further, 3rd and 4th Amendments imply that there is some sort of expectation of privacy, that you need a warrant to come into your home, that the government can't just quarter troops in your house. And the word privacy was a word that was used for toilets in the 18th century. So the founders never would have said a right to privacy. The Second Amendment also isn't very clear, that it talks about a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. And this question of doesn't mean that the right of the people to keep and bear arms, is that a definition of a well-regulated militia, or are these two separate things protected by the Constitution? And I put up a video that explains this. I know we watched it in class, but I put it on that playlist that I mentioned on modules, or linked to my modules, that kind of goes through this issue again. So these rights are controversial, and their existence really depends on who's sitting on the Supreme Court. And it's possible that their protections and whether or not they are acknowledged as being fundamental rights, that can change depending on who's actually sitting on the court. So pro-life organizations, they really want presidents to appoint judges and justices that don't acknowledge the right to privacy as being a fundamental right. That they would say that's something that's up to the states and that's something up to Congress. It's not something for the courts to decide. And then the pro-gun organizations, they want presidents to appoint judges and justices that read the Second Amendment as protecting gun ownership as a fundamental right. So the NRA definitely would support presidents appointing judges and justices that acknowledge that the Second Amendment is something that does guarantee an individual right to own a firearm. That it's not some sort of separate thing relating to a definition of militia. So again, when we talked about like the lasting effect of who was appointed to the Supreme Court and to those lower courts, the district and appellate courts, they're there for life. And how they interpret the law and their views on laws such as the 14th Amendment and its protection against the Second Amendment. Or does the 14th Amendment guarantee a right to privacy? So depending on who's sitting on the court, these things can change. And that's why you hear a lot about Roe v. Wade when we talk about who's going to be appointed to the Supreme Court. Because if you get enough justices that say there is no right to privacy in the Constitution, that then means that states would have the ability to make their own decisions about abortion laws. And there's currently a case that the Supreme Court heard, it was about 2 weeks ago, and they're going to make a decision about this in June. They'll make their decision and make that public. But I can link to some information about that particular case. But it matters who sits on the court. So making your way through the case organizer, we've gone through all of the important cases that are part of or required by the AP exam relating to civil liberties and civil rights. So hopefully you followed along and completed this organizer. And if you need any more help, go to Canvas and click on the Civil Liberties playlist, and that will take you to a few videos that I posted made a playlist for relating to a bunch of different issues, a bunch of different